Hey, Raindrops, we're back for another episode of True Crime Thursdays with Ebony K. Williams. And Ebony, as always, since our last conversation, so many things have happened, and I can't wait to get your insight on all of them. So, first thing first,
Yes.
Kanye West showed up to court last week, but was denied entry because apparently he was not on the guest list. Kanye West, a controversial rapper himself who
Mm.
has some crazy things in the past couple of months and years, but we're not here to recount that because Kanye, as of today, is not on trial.
Uh-huh.
But he was denied entry, but I did find out that as of yesterday, I believe, he can now return to the trial because he is now on Diddy's guest list. And if Kanye West does return, he will have a seat next to Combs' family. So I want to ask you this.
Yes.
If you are a part of Diddy's legal team, would you want Kanye West there to support him in the eyes of the juror? The jury.
No. The answer is no. It's a resounding no. It's a fast no, Carlos. It's no across the board. And let me tell you why I say that. Now, in theory, one could imagine a scenario in which having celebrity, wealthy, famous friends in support of you could be a good thing, right? It could theoretically indicate a wink of sorts to the jury that he is supported by the power brokers to be. I think a few things, Carlos. I think right now in this particular day and climate, I think there's a real cloud over the head of Hollywood and the power broker class in general, to be honest with you, right? I think that there is just an overall sentiment right now, Carlos, amongst the general public and the general population that anybody that is involved in that Hollywood scene of the highest echelon probably is up to no good, as we say, old school in the South. Not indicting Kanye, like you said at this point, just saying that I think that is the overall reputation, quite frankly, of the highest echelons of Hollywood. And I think, like you said, nobody's unaware of the highly controversial remarks that Kanye has put out via Twitter, X, whatever, ranging in everything from anti-blackness to misogyny to anti-Semitism and so on and so forth. And because you've got a jury of 12 people, Carlos, that come from a wide variety of walks of life, we just can't assume that he hasn't offended somebody on that jury just by virtue of what he puts out into the population. So I would say no to wanting my client, my defendant, to be associated with anything that they may associate with Kanye West.
Which makes me ask you this again. I know we brought this up before, and it's interesting because the mother of a couple of Rick Ross children, she questioned why Diddy's celebrity friends aren't there supporting him, and she even named the father of her children. Do you think it will help? So Kanye West, obviously, with controversial past, doesn't help. Does Ebony K. Williams think if any of the, for the sake of the argument, non-controversial celebrity friends that Diddy has, if you were on his team, would you want some of those people to show up in support of him?
I would say this, Carl. I don't think any of it moves the needle, but so much. But hey, just for the sake of this intellectual legal exercise, if say Mary J. Blige was to show up and sit on one of those first two rows in the camp of Diddy, that couldn't be more helpful than hurtful. Why? A, Mary J. Blige is a woman. B, she's, for those that are familiar, know of her to be at least 30 plus years in relationship of some sort with Sean Combs. To my knowledge or recollection, I don't think anybody has anything particularly bad to say around any criminal wrongdoing or anything of that nature. So I think somebody like Mary J. Blige could maybe be helpful. Maybe, but outside, just kind of someone to show that this man is capable of being in a relatively healthy, safe, long-term relationship in the professional sector with a woman. You might want to make a similar argument to Faith Evans, maybe, but I think it's very few and far between is the point. 112 sitting back there not going to do it. Mace sitting back there ain't going to do it. Like what are we talking about? So who could construct a narrative that could be helpful? I think it's very few people.
This case is so interesting because so many bombshells are happening almost every day. Mm-hmm. Most recently, juror number 6 was dismissed, which is interesting because what happened with juror number 6 was the question of his residency, whether or not he's being honest about where he lived, because during jury selection, he has said he lived in the Bronx, but later suggested he moved to New Jersey, mm-hmm. which makes him ineligible for a Manhattan federal jury. Now, those are the facts. But again, when it comes to court cases, as I'm learning with the University of Edmund K. Williams Law School that I'm attending.
Right. Come on, admissions.
Okay, I'll take my LSAT later. But one thing I want to ask you was, juror number 6 did happen to be a Black middle-aged man
who liked hip-hop. Mm-hmm.
Who liked hip-hop. So, although the facts are the facts, him being a Black man who liked hip-hop, is that something that the prosecutors, use to really remove him and let the record show he was replaced by a white male?
A white male who lives in Westchester, which is a suburb. So you kind of think more, maybe we could presume maybe more disconnected from the hip hop culture and hip hop community. So a couple things can be true at the same time. So let's talk about something called discriminatory intent and discriminatory impact. Okay. So if I'm the defense, as they rightfully did in this case, I'm absolutely arguing, Carlos, that this juror is being targeted because he's a Black man, because he is a fan of hip hop, because he is likely more favorable in his lens and perspective to my Black male defendant hip hop mogul client. And I'm going to argue to the judge that this is an unconstitutional removal because it is being done on the basis of discriminating against race. Okay, that is the right legal argument to make. However, the judge considers that, but then weighs that against what the prosecutors are arguing, which is, heaven forbid we would do such a thing. We are only asking for this man's removal because he was dishonest and misrepresented his location, his residence. And not only is that a problem on its face, because it, like you said, Carlos, disqualifies him. If he lives in New Jersey, that's literally out of state, you wouldn't be qualified for. But they're also making another point, Carlos, which is that it goes to prove his untrustworthiness in general. They're actually saying that because he lied about where he lives, he cannot be trusted to render a fair and honest verdict. That's really their argument. And then the judge weighs the two. And in this one, the judge to me was a little swift, I thought, in his ruling. He kind of was extremely dismissive of the defense argument that race was no consideration whatsoever, and just happily plopped the replacement, the alternate juror in his place. So, I personally, I might renew that on appeal or after this verdict is up, because I do think with the jury that is this, what's the word? It's just so critically important, Carlos, that the racial and cultural makeup of this jury be as representative as possible. And with the adding of this alternate for juror number 6's new position, right? 57, I think, Westchester County, white male. Now this jury is even whiter, even older, even more suburban. And so that can have an enormous impact on the overall outcome of this case.
Which is true, because the thing I always relate this back to is the O.J. Simpson trial.
Yes.
Which that particular 12-person jury, it did consist of 10 women and 2 men, who were selected from a pool of 40% white, 28% black, 17 Hispanic, and 15% Asian individuals. The final jury was 9 black jurors and 2 white jurors and 1 Hispanic juror, which a lot of people said that is the reason why. Not the reason why. Let me say that it didn't hurt.
You kind of can say it.
Okay,
you actually can on this one, because there is no way on God's green earth that you're telling any of us with good lived experiences as Black folk that same verdict would have been likely, not impossible, but would it have been likely if that was 9 white women? Come on. So this is why voir dire matters. And there's a reason why, Raindrops, we have these constitutional boundaries around discriminating on the basis of race, gender, et cetera, et cetera. So it's a real thing. This is not imaginary. Woo, woo, woo. There's real precedent. There is real case law. And there are real constitutional protections around this very issue, Carlos. So no, this is very important. It's very important.
Okay. Why was it important, Ebony, for the jury to watch the freak off videos? So on Monday, they had to wear their headphones, and they did watch excerpts of videos showing the orgies that Diddy hosted, allegedly, described as freak offs, hotel nights, and wild king nights. Why was it important for the jury to see these images and watch this video?
Okay, so let's frame it, right? Number one, we know that the only reason that the jury, and just so Raindrops know, the public sitting in the courtroom did not see these videos, okay? The only people that saw these videos were the 12 people on the actual jury, the judge, and the lawyers, right? So they're able to see these screens, and like you said, they have in their earphones. But the galley, the people sitting in the courtroom watching, were not privy to that. The only reason that they saw this and heard, the corresponding audio, Carlos, is because the prosecution wanted them to, right? We certainly would not have anticipated the defense, proposing this type of evidence. So the prosecution, who had seen all of this in pretrial discovery, decided that they felt this had what we call probative value, that this would help them prove a particular thing that they want to convey to the jury about Sean Diddy Combs. I would have to imagine, because we know he's not being charged for sex. He's not being charged for orgies. He's being charged for sexual assault, coercion, abuse, things of this nature. So it would lead one to reasonably believe, Carlos King, that somewhere on those freak off tapes are going to be clear visual examples and audio examples of depraved behavior, depraved language, depraved physicality, perhaps on the part of Sean Combs, that go to prove the veracity of their argument, meaning the prosecution's argument, that this is a man where you're seeing on this video, apparently, or one would think, reasonably believe, it must be going to show on the freak off videos, Carlos, that he is in control, that he is manipulating, that he is the driver, that he is curating activity that other people don't want to be participating in, and that you must be able to convey from this video and audio that you can make the correlation, jurors, that these people are doing things against their will. It only would make sense that should be able to be construed from watching these clips of these tapes. I think they saw 3 clips from 2012, 14, and 16, I believe. Because if not what I just laid out there, I don't know why you do it. I don't know why you add to the salaciousness, because again, there's so many things, Carlos. We have sat here week after week after week for 6 weeks plus, And every time we sit down, there's the law and there's the facts and there are the witnesses, and then there's all this salaciousness every single week, right?
Mm-hmm.
And all I really believe that goes to do is distract the jurors from what they are supposed to be doing when they get into that jury room, which is assessing evidence, witnesses, statutes, pieces of evidence to formulate a verdict. But the more that they are distracted by the noise of all the things that are not in that indictment, I think the prosecution hurts themselves. So I hope that they did not share that video for the sake of look at how disgusting he is, because he's not being charged with being disgusting. He's being charged with coercion, force, things that prove you had people do things against their will, and you used every resource, including your money, your fame, your power, your businesses, your business employees, guns and arson and kidnapping to do it. Anything on that tape that doesn't lead to that was a misstep.
And the way they got these tapes, Ebony, was it through the raid of his Miami and LA homes, and that's how they confiscated it for the prosecution to show it to the jurors?
That is correct. And that is why we're seeing it under the testimony of the special agent who was a part of the investigation. Yeah, so that's the, you have to have an entry point to introduce this type of evidence. And so that's the entry point. Exactly, Carlos. From the raid, confiscated, now they have, access and the ability to decide. What's interesting is the judge could have decided not to allow this in, by the way. Keep in mind, raindrops, every piece of evidence has to be essentially greenlit by the judge. Just because you have the evidence doesn't mean it gets to come in. So it is worth noting that the judge saw this in advance and decided that whatever prejudicial effect, because it is very prejudicial to see any individual in this setting, right? I think we can all agree on that. And the judge said that apparently whatever is indicated on these tapes that goes to prove the elements of the underscored predicate acts that are inclusive of the indictment, he felt that was more important and more valuable than how bad it made Puff look. So he made a decision to let this in.
This is not even a legal question. I think it's more of a psychology question. Ebony, we know that sometimes murderers may keep evidence of, of the crime they committed. What is the psychology behind Diddy keeping these freak-offs tapes as a library in his various homes? Is it, and again, it's not a legal question. I'm really dumbfounded by it.
Actually, pupil, it is a legal question. Let me show you what you just did brilliantly, Carlos. You've been really taking this in well, my darling. So in addition to, I know what you're getting to, in addition to the tapes serving as a trophy of sorts, right? So that's kind of what you're alluding to. Yes, let me keep a lock of hair from the little girl I just assaulted or the kidnap. It's some of that, but the legal piece, and this is where the prosecution is definitely going to come back to this in closing argument. It's so that he can use these tapes and what is on these tapes to threaten, blackmail, and coerce the individuals doing things on the tapes. So when somebody gets on the stand and says, well, I really didn't want to do it, and I wanted to stop doing it, and I wanted to leave and go in a different direction and escape all of this horror torment, Sean Combs said, if you do, I will show the world what you did on those tapes. But he can't do that if he doesn't have the tapes. So he must collect and maintain this library of blackmail support so that he can coerce and force individuals to do things they don't want to do. That's very much a legal question, and that is very much a part of the legal argument that these tapes were not just for his sexual satisfaction, but they were also now tools of coercion themselves. The tapes become the tools of coercion. See how that goes?
Yes. Okay. This is why I love having you on, because I just thought about that too, but now it all makes sense. He could have been using this as a form of blackmail, which is what we did here before.
People did testify to that. Yeah.
They testified with that. So raindrops, as you all know, by the way, Ebony K. Williams, I was in London recently and baby, I'm trying to enjoy Beyonce. And the raindrops, this is a true story, at the Beyonce concert, the raindrops came up to me and said, I love your True Crime Thursdays with Ebony K. Williams.
Yay!
I promise. It was back to back. I'm like, hi. They're like, we like True Crime Thursdays with Ebony K.
Yay! We're international, honey. Yes.
I want you to know that. Like, you have a lot of fans in the UK, honey.
We got to go have some tea and crumpets, honey. We got to go back across the pond.
Yes. You do, baby. So I want you to know that because, again, raindrops. Ebony has said this from the onslaught of us doing this for the past couple of weeks about how the prosecution is really trying to summarize that this was a criminal enterprise. Yes. And Ebony was right from the beginning, because what happened recently is the jurors saw additional business records of credit card statements that showed that Puffy used his American Express for Cassie and a male escort to fly separately to New York City in December of 2009. They also was shown a bank statement from one of Puff's businesses, Bad Boy Entertainment Worldwide, that paid $369,000 to cover the cost of the trip, along with other expenses. The bank statement obviously helps support the prosecution's claims that Puffy used his business to engage in sex trafficking by flying escorts across state lines. Ebony, you have been saying that from day one. It finally happened.
Finally dropped.
Talk to us about that.
Well, this is what we call the shooting gun moment, right? Old school Perry Mason style. We can have these witnesses, we can have these pieces of evidence, but ultimately, what does the jury want to see, Carlos King? They want to see that smoking gun. They want to see the piece of evidence that connects all of this narrative you've been telling me this whole case. I would say this is it. But believe it or not, in this case, with all the baby oil and stripper shoes and videotapes, the smoking gun comes down to bank statements. It comes down to state pieces of paper, folders, pieces of paperwork, essentially, right? That goes to show that the Combs enterprise of it all, the Bad Boy records of it all, that the business entities themselves were being leveraged. These are important words, Carlos, right? Leveraged to financially underscore, clean up, and support and finance the activities, the predicate acts of transporting individuals for the purposes of sex work. And not necessarily that Cassie was, because you want someone say, well, is she a sex worker? Is she your girlfriend? Let's leave her. But the actual male escorts, it's not ambiguous. It's unambiguous. Transported across state lines on an airplane, paid by who? Combs Entertainment. Bad Boy. Let's also talk about the fact that they had bank transfers. Carlos talking about, I think it's a $50,000 cleanup fee for the astronomical damage done at the Intercontinental Hotel. Now, he could have easily paid for that out of his personal account and just said, I was a bad boy doing bad things, but that's my business. But you didn't. You actually made it your literal business when you paid it out of the Combs Enterprise account, which is what the evidence shows.
And that's why your tax accountant always tells you you have a separate business debit card.
Don't make me go get my wallet. Don't make me go get the wallet, Carlos. Because we got this card for this, and we got that card for that, right? Okay.
No, but it's fascinating because it's one of those things that you don't think about until obviously you hear about on a trial that, yes, the fact that you paid for services on your business card can get you in trouble based on the fact that, like Ebony said, so eloquently, by the way, he could have said, I'm a bad boy doing bad things. Take my personal Visa from Chase Bank, honey. and
Mhm.
pay for this
Citibank,
cleanup.
honey. Citibank, whatever. Put it on a personal rush card. I don't give a damn. But this here,
I hope y'all caught that. The rough card was something else.
you got to be a grown up to know what that one is, Carlos. Got to be grown. So, see, it wouldn't pay for us to be in person. It would not pay for us to be in person.
No, Ebony, you're funny to me.
Yeah.
So, as you all know, Ebony is a judge on her own court show. And if you guys watch, she is amazing at it.
Yeah.
But Ebony, somebody is coming for you, girl, because this judge, I don't want to butcher his name, Subramanian.
Subaranian.
Subaranian.
Mm-hmm.
Baby. Yep. So recently, he tore into the lawyers on both sides. Yes, after sealed information was leaked to the tabloids. Ebony, he read these lawyers for filth. This is your jurisdiction, because I was like, child, this is what Ebony does as a judge, honey, on her show.
He said it like a good, strong black mama, baby. He said, somebody lying. Somebody lying. So essentially, Carlos, he chastised both sides, and he called up both lead counsels, Prosecutor Comey and the lead guy for Puff's team. And he said, y'all's job is to make sure that things don't leak. Because, let me say this to Raindrops. First of all, there is a gag order in place. That's the first thing you have to remember. A gag order was put in place pre-trial to ensure that information from either side would not be leaked to the public and press. Okay. There are some things that the public has access to. There are some questions. They're obviously, open court all day, but there are things, Carlos, decisions, things of operation that are called sealed. Okay. They are under seal. And when something is under seal, the only people that are supposed to know are the defense, the prosecution, and the judge. And the fact that, and this all came out because a press outlet was trying to contact who they thought was juror number 6, which would have been the dismissed black man from the Bronx or Jersey that likes hip hop. That's who they were trying to contact, but they made a mistake and contacted a juror who is still actively sitting on the case. And the problem with this, Carlos, is that the only way that they would have had any information about any sitting jurors is because somebody told it, meaning from the prosecution's team or the defense team, because they're the only ones with the information. Why? Because it's under seal. So the fact that an outlet was able to make that kind of mistake and even had contact info of an active sitting juror means that somebody is lying. Somebody's team put that information out in the universe in hopes that it wouldn't be traced back, and in hopes that that dismissed juror could be contacted and interviewed and, create a headline. Well, be careful about trying to make the news. Be careful about trying to win in the court of public opinion, because whoever did it has really cost themselves. And this judge is not playing. You're correct. He's got all the swag and sass and all the things to do all the things. He said flat out, Carlos King, I'm going to do an investigation. I'm not letting it go. And when I find out which one of you two sides is lying to me, you're actually going to be held in contempt of court. And I'm not sure it will just be civil. I might take your ass to criminal contempt. That is what he said.
Okay. So when a judge holds a lawyer in contempt, can you explain to me the difference between a civil charge and a criminal one that he can invoke?
Yeah. So civil, it's normally going to be the punish. It's about the punishment, right? And it's also about what's on your permanent record, if you will, right? So as lawyers, we all have, let's go back to school. We have a permanent record. And while it's never good to be held in contempt, period, as an attorney, because it's a disciplinary measure against you that lives in your permanent record, no matter what state you practice in, no matter appellate court or superior. That is Who wants to hire a lawyer who's been held in contempt? You know what I mean? But civil is more customary. It's the thing you see sometimes. Like, for instance, when you see on television, Carlos, and you see lawyers running their mouth and the judge says, rings the gavel, that's enough. Silence in the courtroom, and the lawyers keep wanting to talk. You're in contempt. That's civil contempt. That's take you away, put you in a holding cell, but ultimately I'm going to let you out, but you're going to maybe pay some money, right? You're maybe going to get a fine, and it's a slap on the wrist, and don't do that shit no more, basically.
Okay.
When you're talking about civil contempt, that could be an active jail sentence. That could be, oh baby, you're going to do some time, and not in a performative way. It could be in a real way, because it's a higher bar. It's a higher threshold for wrongdoing in my courtroom, such that it has arisen to the level of criminality. And I think he has the facts for it, Carlos. This judge would have the facts for a criminal, because a gag order was in place. You actively broke it. You intentionally leaked information that frankly could get someone hurt. When you're leaking contact information of public servants who are jurors, their home address, their telephone, someone could get hurt. And let's say that person gets hurt. You should be held to the highest standard of the punishment of the law. So that's the ideology behind all of that.
As a lawyer and a person with common sense,
yes,
do you think there's any funny business that did go on between the lawyers that this happened?
Somebody is lying. That judge ain't wrong. We know that to be true, Carlos. It was under seal. Carlos, okay, if you and I have a conversation, and we say we're gonna put a number in the envelope, and I show you it's a 2, and it's a 2. You see it's a 2. I see it's a 2. I'm gonna put it in the envelope. And then next thing you know, the New York Times says Ebony K. Williams and Carlos King are, going back and forth over the number 2. Negro, how they know it's 2? Yeah, somebody lying. And that man ain't playing.
Oh,
I don't think he likes being lied to, Carlos. That's the thing. So, yeah.
Yeah, he is. Okay. Last question of the day, Ebony. So, former assistant to Puff, Brendan Paul, pleads the fifth and receives immunity under testimony. He took the stand to invoke his Fifth Amendment right against self-incrimination before taking the stand. He was granted an immunity order, which requires him to tell the truth to protect himself from prosecution. So, Ebony, last question, because this is the most important thing to me as I'm in law school. And I want to make sure that, my years of watching, LA Law and Order.
The
practice, okay?
Yes.
Perry Mason, as you said, and Matt Lockchild.
That's it.
That I got this right. So, pleading the fifth. Because it's a game we play when somebody asks us a question.
Oh, yeah.
I plead the fifth, child, and you move on from it. Can you explain to us? Okay, the former assistant pled the fifth. He received immunity. Explain to us what happens, what that means, because to say that it requires him to tell the truth to protect himself from prosecution, is this a get out of jail free card?
No. Okay. So, well, yes and no. So let's go back to, where does the phrase plead the fifth come from? I think this will be helpful. So that is a reference, Carlos, to the Fifth Amendment of the United States Constitution. Let's zoom out. So we know there's many amendments. We know the First Amendment, free speech, Second Amendment, right to bear arms. There is a Fifth Amendment that says you as a citizen have a right to not incriminate yourself. There are other things in the Fifth Amendment, but that is one of them. You have a right. So that's why when you hear the Miranda rights, which you've seen on all those shows you mentioned, you have a right to remain silent. That is a part of that Fifth Amendment. That is saying that you are not forced in any circumstance, whether it's while being arrested, whether it's talking to the police in your car when you get stopped for a traffic ticket, or even in federal court under subpoena. You never have to give the state or the government information that could ultimately harm you. You just don't have to do that. You don't have to do that. Now, you might have to give them information that can harm somebody else. That's hence the subpoena. but you are protected against having to cause yourself harm. That is what the Fifth Amendment Act essentially says. So when he says, I'm pleading the Fifth, what is inherent in that plea, Carlos, is that if I tell you what I know, it could harm me. So that is why immunity from prosecution is needed to take that harm off the table. So once someone pleads the Fifth and then they are given immunity, they must talk. That's what that means. That means you can't, I can plead the Fifth and be quiet. And if I'm not given immunity, I can stay quiet. But if I'm given immunity, there is no more threat of harm to me. The government or the state has taken that off the table, and now I must speak. You are now compelled to speak. And if you want to stay silent after you've been given immunity, guess what you're going to get? Held in contempt. Is this making sense?
Yes.
Yeah. I got to charge up. I got to go up in my tuition, baby. Yesterday's price, tuition just went up. Yeah.
We love the University of EKW, baby. No, Ebony, thank you so much for breaking this all down. Yes. You have been a resource of help and the source of information. Yes. And this has been another insightful one. I will see you next week. Give my love to Baby Liberty. And make sure y'all catch Ebony on TMZ and all the other outlets she's on as she's covering this trial as well.
Love you, Carlos. Love you, Raindrops. Bye-bye.
I love you, boo.